Welcome to the Sandwich Crunch, where we navigate the trends and issues for boomers and seniors at home, in the workplace, and the community. We are continuing with our estate planning series, and I wanted to actually make a disclaimer before we continue on, as that, first of all, I'm a certified senior advisor. I am not an attorney. I'm not a CPA. I do not practice any kind of financial planning. My father actually volunteers for AARP during tax season. So we are actually sharing with you information that we have personally experienced, we have consulted with our trust attorney about, and we are just sharing this with you because there's so much legalese that attorneys talk about when they're talking about trusts and they're talking about estates and wills, that so many people have said, why don't we just hear it from you guys, because you guys know it so well, and it's much more comfortable hearing it from a family who's gone through this. So that is what I wanted to make the disclaimer about, to let you know where we are coming from. And today we're actually going to be steering into another aspect of the estate plan, and that is the trust. And I know my dad knows this extremely well, so Dad, it's in your hands.
All right. In past segments, we've talked about your estate, which is everything you own or control. Then a will is a number one, in my estimation, necessity, and it can be simple or complicated, it doesn't matter. And then you've probably, okay, let me back up. A will is going to go to probate court. There's no way around it. And whether it's a simple or complicated will, it's going to go to probate. How long it stays there depends on a whole lot of other things. One of those things, and I'm sure every one of you out there has heard people say, avoid probate. And you hear all these horror stories about probate, and they're not all horror stories. There's a lot of truth to what you've heard. So if you can avoid probate, it's a good idea. One way to do it is to set up what they call a living trust. And a trust is a legal entity, and what you do is you set up this trust, and in that trust you say, this is what the trust is going to do with all of the things that it owns. And when you set it up, it doesn't own a thing. But then you, as the person who set up the trust, fund it. You take your car and you have it retitled in the name of the trust. You take your house and have it retitled in the name of the trust. You can have kind of a catch-all phrase that says all of my personal belongings, which would be your TV set and your couch and your washer and dryer, things that you own, but may seem kind of incidental, and you may not want to itemize all these things. Basically, you put everything you have into the trust. If you have a savings account or a checking account, you put that in the trust. You don't put IRAs into the trust, and I'll explain why. So essentially, you take everything that you own and put it in the trust. Now you say, oh my God, I don't own anything. The trust owns everything.
Well, let's clarify what a trust is, because I had somebody give me a really great scenario of how to describe a trust, because I think a lot of people don't understand that a trust is it's like its own business entity. And it was actually our friends at the celebration. She gave me a really great scenario on how to describe it. She said, it's like a car. You fill your car up with all your family, all the beneficiaries, you have your power of attorneys in there, you have your health care directive in there, you have your living will in there, you have your will in there, you have all the things that you own are stuffed in this car, your house, your boat, your motorcycle, the guardianship if you have something set up for that, everything's in this car, and you're driving the car because you control the car right now. But if you become incapacitated or if you die, which we are all going to die, the car keeps going. It's still filled up, nothing leaves that car. It still keeps going. So the trust is like a car filled with all of the things that you control. And I thought that was a really great analogy, because It's an entity all to its own that you just fill with everything that you want distributed within your estate. One thing I actually do want to clarify, though, is that we didn't address this before, is that in probate is public. It is absolute public information. So if you want to protect your estate, you want to have a trust, because then you can keep your estate information private and within your family's domain. If it isn't, once it goes into probate, it becomes public domain.
Public record, yes.
Yep.
The trust, as you said there, is like a car because it keeps on going. And when you set the trust up, you or you and your wife, let's say, fund the trust with everything that you own. And you appoint yourself as a trustee, which simply means you continue to run and write checks and do things as if you didn't have a trust. There's a few little technicalities that you have to follow, but on the whole, you run your life just like you're running it now. It doesn't change anything. But the trust does not go through probate. And it is one of the only ways that you can avoid probate. A will does all of its things and will be probated. But within a will, you can have what they call a pour-over will, or a pour-over section to the will. I don't remember how they set that up. Essentially, what the pour-over does is it says, okay, you put everything in there, but you bought this new boat and you forgot to put it in the trust. The pour-over will say, okay, within limits, it will take all these things that you forgot to put in the trust and put them in for you. So when your estate hits probate, they take a look at the will and they see a trust and they see the combination of the trust and the pour-over, and the estate court says, there's nothing for us to do. Rubber stamp it, you're on your way. Because the trust takes care of everything that you might have ordinarily taken care of in a will. So that's how you avoid probate, with a trust. To emphasize something, in estate planning, the trust is not going to save you a penny in estate taxes. That's a key thing. A lot of people think, oh geez, if I put this in a trust, it's going to take me out of the estate tax situation. That is not the case. There is a kind of, by the way, a living trust is what they call a revocable living trust, which simply means you can revoke it. You can cancel the whole thing if you want to and undo all of the things that you put into it. Or you can change it. It's a living document that you can work on and change. If you want to avoid estate taxes, which currently you have to have quite a bit of money before you have to worry about that, then you go into what they call an irrevocable trust. And what that means is you take money or things and you transfer them over to someone else. The Humane Society as an example. And once you do that, whatever it was you gave to the Humane Society is out of your estate. So when you've sat down and in the beginning of all this estate planning and listed all the things that you own, you don't own that thing anymore. It's out of your estate. So it will not be in your trust, and it will not be in your will. It will not be in your estate. So it's gone. You gave it away. And if you have a large enough estate, by giving things away that way, you reduce the size of your estate and therefore the potential of estate taxes. But that's one of the only ways that there's lots of other more sophisticated types of irrevocable things that you can do. But the bottom line is that's the only thing that's going to save you on estate taxes. For most of us, the size of our estate is not going to get us into any trouble with estate taxes.
No, but it is important to know to set up the trust and get that going if your estate, first of all, is large enough to determine if it needs an estate. If you don't own a home and you just have your cat and it's just you here, a will would be perfect. But if you do own a home and you have children that you need to worry about, as we've said before, conservatorship and guardianship, or the other thing which we didn't mention earlier, there is one thing that you can put into a will that is not placed inside a trust, but it also could be in a trust, but in a different format. In a will, you can actually have a testamentary trust, which is, say you have a disabled child, and you want so much money to go to this child when you die, and you want to place it in the will, but you don't want Aunt Joe or their dad or their mom to manage the money. You want to make sure it's going to, say, a facility if the person's in a facility or in some kind of a home, and you want it to go directly towards their medical care or something like that, that you can place into a testamentary trust, and that is completely irrevocable, and it only goes to the individual it is assigned to. And then there are a lot of rules and regulations that go with that. And I do want to clarify that there are a lot of different types of ways to set up a trust. And like you mentioned, if you want to give it to the Humane Society, there are different ways that you can do that using annuities, using life insurance policies. There's multiple different avenues that you can pursue to help reduce your estate, which we mean reducing your estate, the amount of your estate value. That's what we're talking about. And the other thing I wanted to clarify is funding an estate. A lot of people, I think, are going to get a little confused. What does funding an estate mean? And I believe you mentioned earlier, it is how you title something. So, for example, if your name is Mary Smith and you name your estate Mary Smith Estate Trust, then you retitle your property Mary Smith Estate Trust, and you can retitle your bank accounts, your insurance, you can retitle your home, all the vehicles you own, and all that means it's funded into the trust. So the trust now owns it. It takes it away out of your name. But the other thing I wanted you to talk about a little bit further, Dad, was the management of your trust, because you can put all your assets in there, including your investments, which is your stocks and bonds and anything like that. You still have total control over it.
Right. Because when you set up the trust and you fund the trust, you've named yourself the trustee, which means you get to keep running the show just like it always was. The only difference is everything is in the name of the trust. So your checking account might say, as an example, mine happens to be the Brockett 2007 Living Trust, and that's the name on the checking account. It isn't Richard Brockett, it's the trust. But when I sign it, I am signing as a trustee, or the trustee in this case. So you continue to operate and live your life as if nothing else has happened. The only difference is if somebody from the outside world comes and looks at your house, and let's say they've got they want to sue you for something for the sake of argument, they look at it and you don't own your house. You don't own anything. Your trust owns everything. And I've been told, at least, I've never experienced this, that it makes it a whole heck of a lot more difficult for somebody to sue a trust than it does to sue an individual. Hopefully none of us run into any of this, but...
Well, on that note, Dad, we're going to take a quick break, and I wanted to address the audience again. I'm a representative for Area 12 on Aging for our county, Calaveras County, and we are reaching out to our county to find isolated seniors, those who are living on their own, who don't have family, who don't have access to transportation, who are in a geographically very remote area. We are looking to you to help us reach out to them so that we at Area 12 can provide services and needed services for that person and ways to help them, whether it's helping them at home or getting them to the grocery store. We have a variety of services and programs that can help isolated seniors. So I ask that you get in touch with Area 12 at 532-6272. And again, we ask that you look for those isolated seniors and help us out. So now we're going to go back into the trusts, and you left it off a little bit, just touched on a trustee. So what is a trustee of a trust?
Well, I'm not quite sure how to explain that, but essentially the trustee is the person who manages the trust. And since you set it up yourself and appointed yourself the trustee, then you manage the whole thing. Whether you do a good or bad job, there's nobody to complain to because you're doing the job for yourself. But the trustee is the legal and responsible person for operating the trust. Mm-hmm. Going back to when you mentioned a testamentary trust, what that is by definition is, for the sake of discussion, let's say that you want to give your daughter $50,000 for down payment on a house. Well, you don't trust this going into somebody else's account, so you want to make sure that it absolutely goes to her and gets used for a down payment. So you set up a testamentary trust. And what happens is nothing happens until you pass away. And at that point, that trust activates. And it gets funded from your estate. And now that is an irrevocable trust set up for your daughter to buy a house. She can't buy a car with it. All she can do is buy a house with it. So you're kind of controlling your money from the grave, but you can change it. You know, just because you set up a trust in your will, and then later on you say, oh, first of all, she doesn't need that much money, or she needs more money, or somebody else needs the money, you can change it. Nothing happens until your will is activated.
Well, that's a very powerful thing, the will. So now there's something that is also included in this, that when you become incapacitated, if you've appointed a power of attorney, a durable power of attorney, that would be for medical care, you also can appoint a power of attorney for finance and legal documentation, which is absolutely recommended by the ABA, which is the American Bar Association, that you have two independent individuals that are doing each one. So you have one for your medical care and one for your financial and legal. They do not recommend that you appoint one person. They will actually make you sign an affidavit that says, if you said, no, I just want Joan over here to manage both my health care and my business affairs, they will say, okay, well, you have to sign this affidavit stating that you have allowed this to happen, because it can create a great deal of dissension within the family because there's not a lot of checks and balances. And if you didn't have a will and you were incapacitated, you would go to a court, and the court would assign you a separate guardian and a separate conservator. So it's always best to have specific individuals for those. And one thing you've told me on beneficiaries, a lot of them lined up in place just in case.
Yes. If you have, as an example, if you have a life insurance policy or an IRA plan, and when you filled out the paperwork, it said fill out the beneficiaries. So you filled in, for the sake of discussion, you filled in your two children. And then you forget all about it. Well, unfortunately, the way life goes, one or both of those children may not be around when you pass away. And now all of a sudden you have a life insurance policy, or you have an IRA, which is not going to who you originally wanted it to, and so it gets dumped back into your estate. And now, since you didn't account for it in your will, it's now going to be probated. So everything gets screwed up.
So always good to appoint multiple beneficiaries for each thing.
What you have is your beneficiary, and then, can't think of the proper term, but if that person will not or cannot accept his or her share, then this is the secondary beneficiary. And you can go down to the third or fourth level if you want. Odds are pretty slim you're going to get much past the second level, but it definitely pays to have at least, anytime you have a beneficiary, have at least one backup.
At least.
At least one, preferably two for each and every beneficiary. And that is another place that you want to annually, or whatever time period you choose, review your beneficiaries, because you're going to have additions to your family, you're going to have subtractions from your family, you're going to blend two families together, you're going to have all kinds of changes. And if you don't monitor that, then unfortunately when you pass away, all of those great plans that you made in 1997 are shot, because in 2014 those same people aren't around.
Or something happened to them.
Yeah, or something, or not in the same capacity at least. So beneficiaries, wherever you run into them, be careful. Think through who it is you're putting down as a beneficiary and as a backup. You know, a contingent, that's the word I couldn't think of, contingent beneficiary. And it's very important to do this and review it, monitor it.
Review it often. I know it's interesting, I was doing a presentation a couple nights ago, and we were talking, several women were talking about their various experiences with estate planning and dealing with who got what, who didn't get what, and you know, from a standpoint of a family who either set up a will or set up a trust. And one thing that stood out for me was there was one woman who, she has a very, very solid trust set up for her family, but they have a daughter that is unfortunately hooked on some pretty serious drugs and is in need of some medical help. And so she is a beneficiary, but in a different manner within the trust. They have a specific, which my dad talked about, the testamentary trust. They have another type of trust that's specifically for her, but for medical expenses only. So not only picking out the beneficiary, but knowing what that beneficiary really is going to need. And also, because there are also times when you know, my son may be making $1 billion in a couple of years for all I know. He's that little money man, and who knows, you know, he would not benefit from inheriting from a trust. It would actually might be a deficit to him. So knowing who the beneficiaries are and their situation as well as your own are all key aspects to picking out a beneficiary. And also sharing with them and letting them know what is going on. Because sometimes things aren't always equally divided, and that may be for a very specific reason. It could be because if you have a disabled child, or you have someone who's been caregiving for you or your spouse. There are a lot of reasons why an estate may be imbalanced.
You just brought up a word that we haven't discussed, and that is sharing what you've done. Sharing your will, sharing your trust, sharing who you've appointed a power of attorney, your agent. All of the things that you've done in setting up an estate plan, you do need to discuss this with the people who are involved. And in most cases, this is your spouse, who probably was an integral part of setting all this up, and your children. Now, believe me, this is not an easy conversation to get started, and even harder to keep going, but it's a necessary conversation to have, so that your children, who are typically, in the classic family, are going to probably be the main beneficiaries of what you and your wife have put together. Make sure they understand. And another thing that I've done is I made copies of all of this stuff and gave each of my two children a manila folder, or actually an envelope, full of copies of all of these different documents. Now, whether they've taken them out and read them or not, I don't know. But at least I know they have them, and they know where all of the originals are. And I've been pretty diligent about what I've been talking about, monitoring the beneficiaries. In fact, I just got through about 2 weeks ago sending off a letter that my attorney prepared for me for the beneficiaries for my IRA, and I happen to have 3 IRAs, and so I had to send it off to 3 different companies. One of them came back and said, oh, you didn't fill out the right paperwork. So I filled out all the paperwork and sent it back in and haven't heard back yet. Another one says, oh yeah, everything's great, we have it on file, and haven't heard from the third one yet. So the point is, I did update the beneficiaries, and I know now that they're good. You know, they're good for another year at least, and then I'll go back and review and make sure that they're the way I want them to be. And beneficiaries only apply to certain kinds of assets. Other assets you have to take care of via your will or your trust.
Well, on that note, just talking about a trust alone is a very elaborate part of an estate planning process, and it is under absolute highest recommendation is that you do consult an estate planning attorney and someone who does know how to do estate planning. You don't just want to go to any attorney, and you just don't want to set it up on your own. You can work in certain ways in possibly setting it up on your own, but it was always, always best to have it reviewed by an attorney, because if it is not properly set up and it's not properly funded, it will be thrown out of court. The other thing is, which we will start addressing in the upcoming series, we'll be talking about your business asset, because a lot of us own businesses. And we will also talk about the non-traditional family that is affected by wills and estates now, because we are no longer just the nuclear family, mom and dad and the kids, and goes down the lane. We've got multiple marriages, we've got multiple kids. So that creates a whole other dynamic in setting up your trust and also setting up your will. So on that note, Dad, I want to thank you, and we're going to have you back, and we'll be talking a little bit more about trusts and definitely talking about the business side. And want to thank you all for joining us, and we hope to see you soon on the Sandwich Crunch, where we navigate the trends and issues at home, in the community, and at work.